Hello, and welcome to topic 5. In this topic, we're going to be learning about criminal law. And in this lecture, we're going to be taking a look at categories of law. So, what are we going to be learning about in this lecture? In this lecture, we're going to be learning about the different categories of law, paying special attention to the difference between criminal law and civil law, and talking about how those two laws overlap. We're going to be talking about how crimes are classified, looking at the difference between felony classification and misdemeanor classification. And then finally, we're going to be talking about the role that the United States Constitution plays in criminal law. So let's get started. As your textbook points out, that in modern American life, laws govern nearly all aspects of our lives. And when you really think about it, if you sort of think about think about your day getting up today and just think about everything you did today and think about the way in which laws either explicitly govern your behavior or in an implicit or sort of an unrecognized way. And so when I think about when I got up this morning, I got in my car and I rode to the store. And when I was driving to the store this morning, I wanted to go 40 miles an hour, but I live in a residential area, right? So the law was telling me I needed to go 25 miles an hour. So right there, the law is kind of controlling me. When I got to the store, and I was walking around and looking at the different foods to purchase, right there were certain laws that were governing me. I had to wear a mask in the store. The types of food I could buy were governed by trade treaties that we've had with other countries. And then when I was checking out, and I don't use cash very much anymore, but I have a credit card, and there's laws that are governing credit reporting and transparency when people use credit cards, etc. So that's just an example of just a sliver of life and the impact that laws can have on your life. Laws can, obviously have an impact on our commerce and the economy, who we trade with, how much we pay people within our economy for the work that they do. The economy and the interest rate is set by law. And so all of those things are examples of laws governing our lives. Laws control our private relationships, again, in ways that we may not always recognize. So, for example, I'm married. You met Mike Big Beard in last lecture. Maybe I'll meet him again today in this lecture. But we're married, so if that's a legally recognized contract, and that if we want to get a divorce, heaven forbid, that there would be a legal process that we would have to go through. Many of you probably aren't married, but think about the relationship that you have with your parents, that they're your legal guardian, right? And that there's certain decisions that if you're underage, that you are not able, certain things that your parents would have jurisdiction over. Most of you are probably of adult age, but if you're still on your parents' health insurance because of the Affordable Care Act, again, laws govern those private relationships with family life, but also in settling disputes, which we're going to talk about in a second with civil law. That law controls relationships between individuals and their government. And so that the relationship that we have with our government is oftentimes defined by law. And the way that the government needs to treat its individuals, again, is defined by law. So, you take a look at that, the quote at the top of that from President John F. Kennedy, that certain other societies may respect the rule of force, make people do things because they're afraid that they're, going to get coercively attacked by the government. But we respect the rule of law. And so the rule of law, while it may have coercive power, that the relationship that we have with other people and the relationship that we have with our government is codified in law. There are many categories of law, but your textbook points to 3 categories of law. They talk about criminal law. Let's put these all up here and then we'll just talk about them separately. They talk about criminal law, civil law, and public law. So criminal law is the body of rules that define what a crime is, the laws that set out the punishment for the crime, and then also the laws that mandate the procedures for carrying out the criminal justice process. And as your textbook talks about, that criminal law is divided into two branches: substantive criminal law and procedural criminal law. And so in the definition, you sort of see those differences, but we'll dig into those more deeply in a moment. A criminal law is about the law regarding the individual's relationship to the state. Civil law is all law that is not criminal. Civil law are a set of rules outlining how to deal with disputes that arise between private individuals or between private individuals and private organizations. And so in many ways, civil law is the law that's telling us, it gives us a standard for how we settle disputes among private parties. And in a second, we'll go into more detail on what civil law is. And also we'll see where criminal law and civil law interact or overlap. Your textbook also talks about public law, and that is the branch of law that deals with the government and its relationship to individuals or other governments. And so public law governs the administration and regulation of city, county, state, federal government agencies. Okay. So, when you think about public law, you're talking about like certain ordinances within a city, parking regulations, zoning regulations, taxation zones within a city. Those are just some examples of public law. But because public law is about the individual's relationship with their government, that criminal law actually is within the category of public law. Okay. But for our purposes, the most important two categories are criminal law and secondarily civil law. So let's look at those in more detail. So as I mentioned in the last slide, criminal law is divided into two branches. The one branch that it is divided into is what is known as substantive criminal law. And what substantive criminal law, it's the branch of criminal law that defines crimes and their punishment. And so as we know from earlier in the semester, what behaviors are criminalized, that is an action that a state legislature will take in passing a law that says if you engage in this behavior, then that behavior is a crime. And furthermore, if you engage in that behavior and you're found guilty of behaving in that behavior, this is the recommended sentence for that behavior, for that committing that crime. And that's what substantive criminal law is. It defines the breaking and the unlawful entering into a house and stealing things as burglary. It talks about unwanted sexual advances with force as felonies, sexual assault. Substantive criminal law is actually defining what behaviors are crimes within state statute or within federal code, because you know that the federal government can also has defines criminal behavior, has criminal law, substantive criminal law. It also tells us what the punishment is, right? So that if you're found guilty of first-degree sexual assault, then that the punishment is, no less than 20 years, right? For example. And so that is set in state law. Procedural criminal law is the laws that set out the basic rules of practice in the criminal justice system. And so while substantive criminal law will tell us what the elements of the crime are, that the actions that somebody has to engage in order to be found guilty of this particular crime, procedural criminal law is basically telling us that when you are working your way through the criminal justice system, that there are certain procedures that need to be followed. So there are certain rules of evidence, the way that it can be collected, and that if it's not collected in that way, then it cannot be admissible in court. There are rules regarding arrest, seizure of contraband, the right that you have to counsel, when that right to counsel begins. And we'll be learning about this procedural criminal law, later in the semester in more detail. And so substantive criminal law defines crime and punishment, and procedural criminal law tells us about the rules governing the criminal justice process. So let's apply some of these concepts in the next slide. Okay, so this is your opportunity to test your knowledge of substantive criminal law or procedural criminal law. And to help us, if we were doing this in class, I would ask class members, but to help us, we've got another guest appearance from Mike Giant Beard Hankinson. Okay, so classifying aggravated assault as a felony, is that substantive criminal law or procedural criminal law? Mike, what do you think? Substantive or procedural?
Substantive.
Oh, and you're right, substantive. And why is it substantive, Mike?
Because it's identifying a crime.
Excellent. Right. It's classified. It's telling us that a crime is classified as a felony. So it's telling us about behaviors that and gives us some indication of maybe what kind of punishment it'll get because it's going to be a more serious crime. How about this? A person found guilty by a jury has a right to one appeal. What do you think? Is that substantive or procedural criminal law?
Procedural.
Oh, you're right. Procedural criminal law. Why is it procedural?
Because it's not identifying a crime.
And it's also telling us the process that somebody might want to take if they were appealing their case. All persons charged with the crime that could result in incarceration have a right to counsel, have a right to attorney. What do you think, substantive or procedural criminal law?
Procedural.
Excellent, procedural, because it's telling us the process that if you are charged with a crime, that there's a certain process that needs to be followed, that you get an attorney. The punishment for auto theft is between 20 and 36 months. Substantive or procedural?
Substantive.
Excellent job. Substantive, because it's telling us what the punishment is.
Right.
All right. And so here's the trick question to end with. A person failed to pay his rent for 3 months and is being evicted. What do you think, Mike? Substantive criminal law or procedural criminal law? Or I'll give you a hint. None of the above.
None of the above.
None of the above is right. And why is that? What happens if you fail to pay your rent?
Well, you often will get kicked out, but you don't go to jail.
Exactly. And so it's neither.
It's not a crime.
It's not a crime, but it's governed by civil law. All right.
Although I think there are, but right.
Well, we'll just leave it at that.
I was going to say that, but now I'm confused, so never mind. Let's pick it up later.
All right. Hopefully you guys are less confused than Mike the Giant Beard. And hopefully you did it good, and as well as Mike did on applying those concepts. All right, so now let's talk about civil law, and we'll talk about how civil law and criminal law overlap, because this is not a class on civil law, but this is a class on criminal law, but they sometimes overlap. So civil law, this is a definition we already looked at earlier. It's the set of rules outlining how to deal with disputes that arise between private individuals or organizations. Civil law also has to do with sometimes a failure to carry out a legal duty, although sometimes failing to carry out a legal duty could actually be a criminal offense as well. So let's look at the different types of civil law, or the different kinds of disputes that are going to arise in civil law. So here are some types of civil disputes. One is the breach of contract. And in that last slide, when we were at the trick question about whether failure to pay rent was a criminal offense, or substantive or procedural criminal offense, and it was neither because it's a civil law, that's because that a rental agreement is a contract, right? So that when you rent an apartment, your landlord and the tenant sign a contract, and the tenant agrees to pay a certain amount of money on a certain date each month. And then the landlord agrees to do certain things on their end, provide heat, perhaps, landscaping, maintenance of the plumbing, etc. And that if either of those people who sign onto that contract violate the contract, then there becomes a dispute. So let's say that you are, renting from a landlord, and you're paying your rent on time, but then there comes a point point where that your place becomes uninhabitable. Let's say there's a rat infestation or something like that, and then so you call your landlord and you're like, "Hey, landlord, there are rats in my house. Like you need to do something about it." And the landlord keeps saying, "Oh, I'll be over there. I'll be over there to deal with the rat problem." But then the landlord never comes over to deal with the rat problem, and so then you stop, paying your rent because the place is you can't inhabit it, and then then you got evicted because you fail to pay your rent. Well, that would be the type of civil dispute that you could bring to a civil court, because you could say, well, which party was responsible for violating the terms of the contract? You could say, well, you didn't pay your rent, but then you could say, well, I didn't pay my rent because the landlord wasn't living up to their end of the bargain, that they wouldn't. How can you pay for a rent for a house or apartment that is overrun with rats? And then the court would settle that dispute and figure out who the responsible party is. Invasion of privacy is a good example of that. Invasion of privacy can also be a criminal offense as well, but invading one's privacy can be a civil dispute. A breach of a fiduciary responsibility. So you can contract with somebody, you can hire somebody to manage your assets, to manage your portfolio. You could trust them to invest your money in the market. But if they are making decisions that are benefiting themselves and not benefiting you, then that's a failure of a legal duty that they had to properly manage your money. The negligence of, and we're going to be talking about this when we get to actus reus, the failure to exercise care, and so that if you hire somebody to, like, let's say, take care of your dogs, and you're going to pay them X amount of money, and then they just don't take care of your dogs, they don't feed them, and the dogs get sick or die, that you could sue them for this negligence, the failure to exercise the care that they agreed to do. It could also potentially be a criminal offense as well. So there are some overlaps. Now, keep in mind that when it comes to when a court, let's say, in the first example of the contract between a landlord and the tenant, when you go to court, and then the court would, and sometimes a jury can do it as well in civil law, they'll settle the dispute, and then they'll figure out who is the responsible party. Now, if they say that and whoever's determined to be the responsible party they need to make a civil restitution. Now, there's no criminal sanction because civil law is not a criminal offense, so they're not going to send the landlord to jail, but let's say the landlord is found to be the responsible party because they didn't get rid of the rat infestation. They may be ordered by the court to pay for damages. So you could say sort of the psychological damage that the tenant was subjected to because they were living with rats, right? Or maybe the rats did damage to the tenant's property. Now, in this case, probably not a good example of completing the contract, but I guess let's say you hire somebody to do some landscaping, and then they don't do the landscaping. One of the civil restitutions could be, well, pay for the damages for waiting, but then you also have to complete the contract, okay? But the big takeaway here is that when it comes to resolving civil disputes, there are no criminal sanctions. So you might be asking yourself, Professor Hankinson, why are we learning about civil law? This is a class on criminal law. Well, the reason that we're learning about civil law is because it is related to criminal law, and that it deals with, in part, personal injury, or what's known as civil tort law. Civil tort law is the law of personal injury. And so when you think about Gruber law offices, one call, that's all. If you've been injured in a car accident, that's tort law. That's a lawyer who is not, he's not a representative of the state. He's not going to charge somebody with a crime associated with an injury, but that he will represent the injured party in a civil tort defense or civil tort suit. And so that's where we see the overlapping of civil law and criminal law, because injuring somebody, personally injuring somebody, could be a criminal offense. But a personal injury can also be something that an individual can sue a person for asking for damages for the injury that they sustained. So a person can be both charged with violating criminal law and they can be sued for personal injury. And the great example of that is O.J. Simpson. Okay. And in a second, when we look at the comparison as you're reading in the textbook, you might be saying, wait a second, isn't this like double jeopardy, being tried twice for the same crime? No, it's not double jeopardy, because O.J. Simpson was charged and tried once in the case, the people of the state of California versus Orenthal James Simpson. He was charged with first-degree intentional homicide. And he was charged and he was tried. And as we all know famously, he was found to be not guilty. So he was acquitted of the crime. If the glove does not fit, you must acquit. Okay. The family of Nicole Brown Simpson and the evidentiary standard there in a criminal trial is beyond a reasonable doubt. So if there's any doubt in the mind of the jury, that's what O.J. Simpson's ace team of lawyers were trying to, put a lot of doubt in the mind of the jury that the lawyers who were racially biased, the glove, didn't fit him, raising doubt, and that was enough to get him acquitted. The family of Nicole Brown Simpson, that was the woman who was killed by O.J. Simpson, or at least accused of being killed by O.J. Simpson. They filed a wrongful death suit against O.J. Simpson, and they won that suit. And so this was a civil suit. It wasn't a criminal case because he was tried and found not guilty. He can't be tried again for the same crime. That does violate the double jeopardy provision of the Fifth Amendment. But in the civil case, he was found responsible for the wrongful death. And that's because the evidentiary standard is different in the civil case. It's a lower evidentiary standard. It's by a preponderance of the evidence. And so if that standard were used in the criminal case, he probably would have found guilty. But we have a lower standard of evidence, evidentiary standard in a civil case. And why do you think that is? And maybe ask yourself, why there's a higher standard in a criminal case. Well, I think the answer to that is because the punishment for being found guilty is a criminal punishment, and it can be quite substantial punishment. I mean, it could be the death penalty. The sanction for in a civil case is monetary, and when O.J. Simpson was found to be responsible for a wrongful death, then he had a monetary fine to pay to the family for their damages. And that's where O.J. Simpson ended up having to sell his Heisman Trophy and all of his memorabilia, which actually led to his second criminal charge, which he was found guilty. But this is a good example of the overlapping of criminal law and civil law. Your textbook does offer a graph that's similar to this, but this is from an older edition of the textbook, and I think it just does a better illustration of the comparison. So on the one side, it shows the similarities between criminal and tort law, and the other side, it's the differences between criminal and tort law. And a lot of this we've already covered, so I'm not going to go over this, but that, make sure you look at the graph that's in your textbook. It's also or you can refer back to the video. It really does a really good job of comparing and contrasting the two different types of law. Okay, so here's a little application of the difference between criminal and civil law. I couldn't get my husband to come for a second guest appearance. I was lucky just to get him for the first one, but so you can play. I'll pause for a little bit so you can sort of think about it on your own. So ask yourself, is this primarily a civil or criminal matter? Okay, let's get started. Marriage and divorce, that getting married and getting divorced, is that primarily civil or primarily criminal? If you answered civil, would be correct. Marriage is a contract, and that when one of the parties fails to hold up the end of the contract, then it is dissolved through a divorce. Okay. And there's civil law that governs the dissolution of marriage, and also civil law that is involved in in marriage. Now, that doesn't mean there couldn't be some criminal offenses, right? So that if you marry an underage person in Wisconsin, you can get married as young as 16 with parental approval. Well, let's say you get married and then you have sex with somebody without the parental approval, that you could be charged with statutory rape, particularly if you were, the other party was an adult. Also, if there's any sort of like domestic violence that takes place in a marriage, okay, that would be a criminal offense, the domestic assault. But primarily it's civil. How about copyright violation, civil or criminal matter? Well, this is a good example of where we see an overlapping of civil and criminal law. You can sue somebody for taking your intellectual or artistic property, right? You write a song and then somebody else writes another song that sounds just like your song. You can sue them for that. But copyrights are it's federal law, and so that if you are violating copyright law by just making multiple copies, pirating a movie and then selling it, that's a criminal. In fact, it's a federal criminal offense. Car accident depends on the situation. And so just because you are in a car accident doesn't mean that you have committed a criminal offense, but you are likely to be sued. But if you are driving in a reckless manner, if you are driving under the influence and you harm somebody, if you knowingly use your automobile to hurt somebody else in a willful manner, those could fall in the criminal category. Identity theft, both. Denied unemployment, what do you think about that? Like, so you lose your job and then you go to the employment office and then you say, hey, can I get some unemployment insurance because I lost my job? That's going to be a civil offense. So if you're denied unemployment they say, hey, you were offered a different job and you didn't take it, you're not eligible for unemployment benefits, you could sue the state for a wrongful denial of unemployment benefits. But the state you couldn't charge them with a crime. Not that the state is really ever charged with the crime. But if you are using unemployment benefits in a fraudulent manner, that could be a criminal offense, fraud. So maybe it even needs to be in the both category. If a confession is beaten out of a person in police custody, it's both a civil offense and a criminal offense. A police officer who beats somebody could be charged with a crime, or who kills somebody could be charged with a crime. They don't often get charged with the crime, but it is possible. But the individual who was harmed by the police can also sue the police. It's a federal offense, or it would be a federal suit. Okay, the last thing we're going to talk about when it comes to substantive criminal law is the jurisdiction and the jurisdictional differences, and also the general classifications of crimes, which we'll talk about in just one moment. So keep in mind that each jurisdiction is responsible for defining and grading offenses, in other words, telling us the seriousness of the offense, and also for classifying a crime, whether or not it's a felony or a misdemeanor, and also setting the punishments. And so, as we're going to find in the next lecture, when it comes to defining an offense, that's in actual state or federal law, that in order to be found guilty of, let's say, sexual assault, first degree felony, sexual assault, that in the law, it tells you what the elements of the crime are, right? It needs to say that force was used. It needs to say that it was, against a person's will. I mean, it will be actually defined, the elements in state law. And as we're going to find in the next lecture, that for somebody to be found guilty, the state needs to demonstrate that the individual is guilty with all of the elements of the crime, not just one. That's not enough to find somebody guilty. Now, keep in mind that states classify and grade offenses differently. And so in some states, a certain kind of unwarranted sexual behavior might be considered like a Class D felony, low. But then in another state, it might be classified either as a higher felony, or it could be even classified as a misdemeanor. In some instances, a certain crime, a certain behavior would maybe not be classified as a crime at all. marijuana law is a classic example of that. And so in some states, if you possess and distribute marijuana, it can still be a serious offense. In other states, you can possess it, distribute it, produce it, and it's absolutely legal. It's a legal endeavor. And so we see that there's different jurisdictions from state to state to state as it relates to criminal law, and the vast majority of criminal law is in the hands of the state. But do keep in mind that and again, marijuana is a classic example of that, is that some states might classify production and distribution of marijuana as legal, but the federal government still sees that as a criminal offense, right? Marijuana is still on the controlled substance list. And so that's when you have federal and state law that will come clashing together, right? Because there are the different jurisdictions. And keep in mind that federal law does trump state law. And so when there's a conflict between state law, like Colorado's legalization of marijuana, and federal law, the federal government could come in and crack down on the state dispensaries if they wanted to. When President Obama, and to the most part, President Trump, although it was really never clear what President Trump's sort of approach to that was. But when President Obama was in office, he said that he was not going to mobilize federal law enforcement to investigate in-state marijuana production in states that had legalized it. They took a hands-off approach. What they did say is that if they saw that the states surrounding Colorado that did not legalize marijuana, if the marijuana was going into those states in an interstate commerce, they said that they would step in, but they wouldn't step in as long as it was within the state boundaries. And that's pretty much the way that it played itself out. Now, when it comes to grading an offense or classifying it as a serious offense or a less serious offense, your textbook talks, and we're very familiar with these two different classifications: felony classification and misdemeanor classification. And your textbook talks about the difference between felony and misdemeanors in two major ways. One is just the sheer seriousness of the crime, and that can be up for disagreement. In some states, what might be seen as a serious offense would not be seen as serious in another state. But there's some offenses like aggravated assault, aggravated sexual assault, homicide, manslaughter. There's not going to be any question that those are going to be felonies. Okay, and so the seriousness of the crime. Felonies are considered more serious crimes: criminal homicide, robbery, rape, and misdemeanors are seen as more of a less serious offense, a minor offense: simple assault, low-level theft, possession of marijuana. Okay, kind of the seriousness. But misdemeanors and felonies are also differentiated between the potential sentence you serve and also where you serve that sentence. And so felony sentences can be punishable by death or longer term incarceration, and so it's usually classified as more than a year, and that sentence is going to be spent the incarceration is going to take place at the state prison, a state penitentiary, or a federal penitentiary. Okay. Misdemeanors it's incarceration for less than a year, so a shorter sentence, and that it's going to be in a non-state facility. It'll be in like the county jail, like the House of Corrections down in Franklin. Okay, if you live in the Milwaukee County area, and the jails are, we'll learn later in the semester, jails are horrendous places because they are run by the county and they usually don't have enough money to run them properly. Okay. And one final thing to keep in mind is that a felony conviction can have a much more grave impact on your life than a misdemeanor conviction. You're not going to lose your right to vote. You're not going to lose your access to benefits like student aid or food stamps or those sorts of things with a misdemeanor conviction. But you could, depending on the state, lose those things with a felony conviction. And so the felony label, it has a more severe consequence on an individual's life, even after they're done with incarceration. Okay, that's it for this lecture. In the next lecture, we're going to be taking a look at the elements of the crime and criminal defenses. Talk to you again soon.